Back again. Good to see you all. So, today we're going to be talking about the Supreme Court. Beyond what we've already covered, I want to cover some basic details just to make sure that we understand how the highest federal court in the United States operates. So, first thing you need to know is that there are 9 members on the United States Supreme Court. That number, however, is not codified or specifically delineated in the Constitution, but it has been a precedent since the 1800s. And most likely, I would say that there's a very good chance that it will stay 9 people. However, there, of course, are vacancies on the court, and those vacancies come about by a Supreme Court member either dying or retiring. It is possible that a Supreme Court justice could get impeached and removed in the same way a president could, but as we learned, that doesn't always work. In fact, it's never worked in terms of the House impeaching and then the Senate actually convicting a president or a Supreme Court justice. So they are removable, but through the same process that a president is removable. And after January 6th, a lot of people would argue if it didn't happen then with Donald Trump, that a conviction is almost probably never going to happen. Because remember, you need that 2/3 majority. And here comes my corny joke again, which is 67% of Democrats and Republicans don't even agree that the sky is blue or that grass is green. So to get them to agree on removing a Supreme Court justice it is a massive deal, and it's likely not going to happen. With that said, I want to tell you a little bit about the current court. So another thing to know about the Supreme Court, if you're writing down their characteristics and or powers constitutionally, besides having 9 people, the way they operate is the United States president, as we said, nominates somebody when there's a vacancy. And then once there's a hearing in the Senate, that person will either get voted onto the court or get voted down, and then the president would have to nominate someone else. But if you're wondering what happened in the court in the last few years, there's a major controversy, and it depends on which side of the aisle you fall on, but for sure, it was something that I think a lot of people, as observers, thought was something that they hoped would never happen, which was the potential for partisanship to take over the idea of having a Senate hearing. So in 2016, when Obama was still president, in February, a very conservative justice on the Supreme Court, Antonin Scalia, died. He passed away in February of 2016, but the reason this is relevant to today is because that then left a vacancy on the Supreme Court, meaning now we only have 8 people on the Supreme Court. So the president's job, according to the Constitution, nominate someone else. The Senate's job, according to the Constitution, vote on that person. Well, and I'll give you one specific senator's basically exact words to make it clearer. But the Republicans said, no, this is an election year. Yes, it's only February, but we don't feel like there should be a vote on whether or not a Supreme Court justice is confirmed until after the presidential election. But remember that the election then, it's February, so the election's not till November. And so you have almost 9-10 months to fill that vacancy. Republicans refused to hold a vote, and because they had the majority in the Senate, they didn't have to hold a vote. People would argue constitutionally they did have to hold it, but what the famous quote is from Senator Lindsey Graham of South Carolina was he said, hey, if it's the exact same thing and it's reversed, where it's Trump's last year in his term and somebody dies or retires, you will not fill that seat then either. We're going to be fair. We just aren't going to have hearings for Senate approval of Supreme Court justices during an election year. We just won't do it, no matter who's president. So as you can imagine, there was a lot of upset from Democrats and maybe some independents as well, who then said, okay, well, let's see if this actually, who wins the election. So Obama had nominated Merrick Garland. If you know that name, it's because he did not get a hearing, even a single one, on the Supreme Court from the Senate, but what he did get was later being the Attorney General of the United States right now under Biden. And it's no slight to that job, but that job is a very fireable job. As we learned, presidents can fire heads of agencies without Senate approval. There's no impeachment and conviction. So he does have a very powerful position, but I'm sure he probably would have wanted to be on the Supreme Court instead. But the Republicans said we're not going to hold a vote at all. It's an election year, even though it's February. If Trump is president next time and someone dies in February or March or any time during that election year, especially after the primary cycle, they said, then there would be no doubt that we will not hold the vote. So when Trump and Hillary Clinton ran against each other, there were only 8 Supreme Court justices on the court. So whoever was going to win was going to immediately get to put someone on there. And that's perhaps the biggest power a president has, because that person's going to be there for a generation or however long they live, or just until they decide to retire. So as you can tell from the story, as Trump won, he filled the vacancy immediately. And then a few years go by, he fills another one. So the court's composition went from being, five Republican nominated justices and 4 Democrat, to then, by the time the Trump presidency was over, 6 conservative Republican nominated and approved by the Senate justices, even though technically they're not justices, they're not supposed to be Republican or Democrat. They're just supposed to be justices. They are put on by Democrats or Republicans, so it's obvious that they have ideological beliefs that go in line with the party or the president that picked them. So as this worked out, the same thing happens, but now, February of 2016, Antonin Scalia dies. There's a vacancy on the court. Republicans say we're not going to hold a hearing, and you can use. Lindsey Graham actually said, hold on to this tape, and he was referring to the video of him being recorded by a journalist, promising that they would not fill the seat if the roles were reversed. In other words, they didn't want to fill Obama's seat, because if they stalled, Trump might have won, and he did, and then he got to fill the seat. So they said, we won't do that. We won't stall if it's Trump, or we will stall. We'll do the same thing. We'll wait until the election's over, and then we'll fill the seat. So Scalia dies in February of 2016. Now go to February of 2020. Still 9 members. March, April, May, June, July, August. 20. How many months are we in? My math's a little off. We've got now almost 20 days or so to the election, or maybe a little bit more. In September of 2020, Ruth Bader Ginsburg dies. She passes away. Now, when Scalia died in February of 2016, the Republicans said that they would not hold hearings because it was an election year. But then when a justice died who happened to be very liberal, you'll never guess what they did, which is to say that they voted on it about as quickly as I think it's ever been done, perhaps in American history, got it approved, and so now Justice Barrett is on the Supreme Court, and so a lot of people were upset that Republicans broke their promise, but there's really nothing for the Democrats to do other than to try to make the court bigger, which is called packing the court. The last president to try to do that was FDR. It didn't work. There was a lot of pushback, and that would just mean a strategy where it doesn't say 9 people have to be on the Supreme Court in the Constitution. It's just like a precedent and a tradition we follow. So that means that they were just trying to say, well, it's not a rule, it's just a tradition. So we're going to add like 5 more people to the court and have them all be from our party. And I think objectively, I respected the fact that Democrats didn't do that, even though I'm not partisan either way, because they could have done it, and then Republicans could have done it next, and then Democrats again, and every time a new president comes and their Congress is majority dominated by their party, they could just continually increase the amount of Supreme Court justices on the court until we have hundreds or something. So I think it's good, at least for stability, for both parties to leave the number 9 alone. in terms of precedent. But it's not in the Constitution. It could change. With that said, let's go on to the next thing. One of the most important things about Supreme Court is they're not elected directly by people. So that means that they don't have to care what people think. So there's a word you could write in your notes for this. I'll give you the harder word first, is autonomous. Autonomous means independent. And if you want to say it a different way, it's they're isolated from public opinion. That doesn't mean they don't know what people think. They know that people largely disagree with, say, Roe v. Wade when you look at surveys, but they're insulated from it. They can't get unelected. They can't lose their next election because they were never elected in the first place. So it's basically a situation. Now, here's the good side of that. If there's an issue that the public is wrong about, like, say, the South during slavery, the Supreme Court should be able to not, they should never have cared. No one should have ever allowed it. But the Supreme Court should not have cared what angry racist Southerners thought. They would have been able to choose, just right and wrong, and they're insulated from public opinion and worrying about winning elections. Again, winning elections should never be an excuse for that. But that's the point. The point of the independence of the Supreme Court is that hopefully they will do the right thing when public opinion is wrong. I'd say one example we already learned about was Brown versus Board of Education. That's a good example of the Supreme Court saying, having black and white people go to different schools, water fountains, different parts of a bus that people are sitting on, you're not allowed to go to certain restaurants, all kinds of stuff with the Jim Crow laws. That type of thing was first started to end when the Supreme Court didn't care what the Southerner governors thought. They were racist. They wanted to keep segregation, but thankfully the Supreme Court didn't have to care what they thought, and they pushed through it anyway and made that decision to force integration to occur. With that said, the next one we're going to say is that Supreme Court justices have steady pay. What that doesn't mean that they can't get a raise for like cost of living or inflation, but what it means is Congress can't say, hey, you all just decided that this bill we passed and the president signed was unconstitutional. We spent a lot of time on that bill and we really like that bill, so we're going to actually go ahead and dock your pay because you decided a court case in a way that disagrees with our vantage point. That's a disaster. The opposite is exactly the same as much of a disaster would be if the president signs something into law and Congress, obviously puts it on their desk. Then Congress goes and gives that Supreme Court justice or those justices that voted for it, they go and give them a raise. That would be a bribe. And it's a disaster when judges are bribable. You don't want judges to be able to take a bribe, especially not when you're talking about Congress having as much power and money as they have, as we said, the federal budget over $5 trillion. So the Supreme Court justices' pay is fixed and steady, and it's meant for that reason. A few more things. If you wanted to know how does a case come to be considered by the Supreme Court, there are just a couple important key elements that all the cases they take have to have in common. Number one, the issue that they're taking up has to be something about the Constitution. So, for example, if you go home today from wherever you work and you get pulled over and you get a speeding ticket and you were legitimately speeding, that's not a case that the Supreme Court, you could go to court and appeal it and say that the police officer's radar gun was wrong, you weren't driving that fast. But that case is never going to make it to the Supreme Court. But say the same thing happens, you get pulled over, but you don't believe that you've sped in this case either, but you believe it's because of the color of your skin, or because you have a Black Lives Matter bumper sticker, or there's a profiling going on by a police officer based on something about you. That then becomes not just a traffic ticket. Now we're talking about, and we'll learn this later, the Fourth Amendment, which prohibits the government, police, from searching or seizing your stuff without probable cause or a warrant. And probable cause is not the color of your skin. That's called racial profiling. And so let's say that second issue we just said goes up to a court at the local level first. The judge rules in favor of the police officer. but the person still feels that they were racially profiled, they appeal even higher. Eventually, every state has their own Supreme Court. So before it would go to the U.S. Supreme Court, all 50 states would have to, in whatever cases originated in within a state, would first go to that state's Supreme Court, after the local courts, and then federal courts of last appeal, and then all the way up to the Supreme Court. And here's the second thing you should know for your notes. So constitutional issues, the second thing about Supreme Court cases, they are taking those cases based on what's called the rule of 4. And the rule of 4 means that out of the 9 justices, at least 4 of them have to agree to take the case in order for them to take it. Now, notice that's not a majority, so they're not predetermining the answer. They're just saying there's enough of us on the court, which requires 4 out of 9 at least, to take a case in order for them to take it. Hypothetically, they could reject every case. Hypothetically, they could accept every constitutional case. But the reality is, out of about 15 million potential cases a year, and if you want to focus on this number I'm about to tell you now is more important than that one, 75 to 80 decisions per year the Supreme Court makes. 75 to 80 cases is the workload that they generally have stuck to for the last several decades. So you have millions of cases that start at the local level, and so this is point number 3. And you could have probably put it as point number 2 and bump point number 2 down to 3. But either way, the way that you get to Supreme Court is to appeal. You don't just show up on the Supreme Court's front steps and say, hey, I've got this issue. You got to go through the local courts. You got to go through the state courts. You got to go to the state Supreme Court, the federal courts of last appeal. And then if the rule of 4 gets all the way to the doorstep, you might be one of those 75 to 80 cases. But it's about like the chances of winning the lottery. It's not very often that your case would get picked. It's kind of depending on the justices and depending on about a million factors, but it is fascinating to see which cases they take and which cases they decide not to take. And there's a lot of power in deciding not to take a case, because what that does is it defers the judgment down to the next highest court, which would be like